Bill Henshaw here again for the Constitutional Crisis Channel. Today's subject matter is an interesting one, a document that I've kind of done that I send out to anybody and everybody that I communicate with in an official capacity to let them know what the situation is. I call it the Constitutional Paradigm. And it goes like this. All of the following are clearly true. Even the old dad Stevens, who was in the 39th Congress, would have to admit all of this. 1. American Revolution, United States created, 1776. Is there any doubt about that, people? 2. Articles of Confederation created, 1778. 3. Northwest Ordinance of 1787 enacted. Secures, quote-unquote, the inhabitants of the territories the rights to habeas corpus, trial by jury, judicial proceedings according to the course of the common law, rights which must res ipsa loquitur exist in the states. That's Latin, by the way. It just means by its own, it's all you have to do is say it. By its own accord, have to exist in the states. 4. Constitution of the United States ordained and established, 1787. The Constitution and laws enacted in pursuance thereof are the supreme law of the land, and Article 1, Sections 9 and 10, Article 3, Section 1, the 9th Article of Amendment secures the rights to judicial courts, judicial process, trial by jury, and the writ of habeas corpus, which is also secured by Article 1, Section 9, Clause 2. 5. Northwest Ordinance of 1787 reenacted by First Congress. This law recognizes the rights of inhabitants of the territories, rights which will continue when the territory is admitted as a state into this union, and with additional rights associated with state citizenship. And the First Congress did this in order to be sure there was no question about that this ordinance was going to apply under the Constitution, because it had been enacted before the Constitution. That's why they did this. 6. Northwest Ordinance of 1787 applied to the Oregon Territory, 1848. You can look this one up. Google 9 Statutes at Large 323 et sequel. The title is an act to create the territorial government of Oregon. I believe for this purpose especially it applies in California where I am right now. 7. Today, either A or B is true, but both cannot be true. A. The several states still exist with creator-endowed inalienable rights and or rights secured by the Constitution of the United States, 1787 to 1791, intact and available on demand. B. The several states no longer exist as such, having somehow been relegated to the status of federal insular territorial possessions. If so, then 1. The Ordinance of 1787 is in full force and effect by operation of law and without the need for any legislative largesse. 2. But would otherwise be territorial tribunals sitting in territorial venues without any judicial power to exercise, must, on the demand of an inhabitant of a territory, quote-unquote, be converted into a judicial courts and all rights available to the claimant. 3. In the alternative, an inhabitant of a territory must have his own court in which his rights can be invoked and vindicated. 4. In either case, such an inhabitant must have more rights than a state citizen, a seemingly astounding absurdity, or all members of the sovereign body politic of the nation and republic who are ordained and established all government to secure the blessings of liberty to ourselves and our posterity, have lost, quote-unquote, their rights and are now slaves in the nation in which they created. 5. If the latter is true, then so are all of the following facts as set forth in the cited decisions of the Supreme Court of the United States and or other authority where readily applicable. A. There is no right to trial by jury in at least a criminal misdemeanor case. Blanton versus Las Vegas, that's Blanton, 489 U.S. 538, 9-0 decision. Brown versus Mississippi, also 297 U.S. 278. There is no right to an appeal in any criminal case Case is McCain v. Durston, 153 U.S. 684. That's McCane versus Durston, Durston. That's in the 1880s, but it's a case the court uses frequently to this day. 3. There is no right to habeas corpus even if one is actually innocent of the charges. Mooney v. Holohan, Mooney versus Holohan, Holohan, 294 U.S. 103. Coleman v. Thompson, 501 U.S. 722. There is no right to effective assistance of counsel in a state judicial court, since no such courts exist or have any reason to exist because the states have been relegated to territorial status. There is no right to challenge the jurisdiction of a territorial tribunal, since those who quote-unquote owe their quote-unquote citizenship to Section 1 of the non-existent 14th War Amendment have accepted this quote-unquote benefit and must bear the burden. F. That an integral, albeit hidden, part of this burden also includes being presumed to be a taxpayer, Ashwander v. TVA, 297 U.S. 288, an artificial corporate entity which has no rights and which can be taxed out of existence without even any administrative hearing, let alone judicial process and or trial by jury. Section 4 of the 14th War Amendment, Enochs v. Williams, that's Enochs v. Williams, 370 U.S. 1. That welfare recipients, on the other hand, have a right to a pre-deprivation hearing before such quote-unquote benefits can be altered or abolished. Goldberg versus Kelly, 397 U.S. 254. Does the regime currently in power adhere to the original intent of the framers of the Constitution as a government of defined and limited powers, or is there another philosophy in play here? Perhaps the following excerpt will be of help, particularly given the spate of well-known violent episodes involving quote-unquote peace officers in the last 18 months or so. Also, this is the reason that I identify our government as the DNSG, the de facto National Socialist Government. You listen to this excerpt and you tell me if I'm wrong here. The first question to ask is the function of the state to be limited or unlimited? Is any area of human life to be inviolate, exempt from government coercion, or is the state to be the all-encompassing and all-powerful? Do men have certain rights which the state cannot transgress, or may the state properly act without restriction in any sphere to achieve its purpose? To this question, Nazism gives an unequivocal answer. The state is to have unlimited authority. It is to have absolute power. It is to have total control over every citizen and over every sphere of human activity. It is to be a total state, quote-unquote, said Hitler's mentor Mussolini, coining the famous term from which the adjective totalitarianism was subsequently derived. Writes Ernst Huber, a leading Nazi theorist, in a definite presentation of the Nazi political legal position, quote, the authority of the Führer is complete and all-embracing. It unites itself in all the means of political direction. It extends into all fields of national life. It embraces the entire people, which is bound to the Führer in loyalty and obedience. The authority of the Führer is not limited by checks and controls, by special autonomous bodies or individual rights, but is free and independent, all-inclusive and unlimited. What happens to personal liberty in a quote-unquote total state? Writes Huber, not until the nationalistic political philosophy had become dominant could the liberalistic idea of basic rights be really overcome. The concepts of personal liberties of the individual as opposed to the authority of the state had to disappear. It is not to be reconciled with the principle of the nationalistic Reich. There are no personal liberties of the individual which fall outside the realm of the state and which must be respected by the state. There can no longer be any question of a private citizen free of state influence, which is sacred and untouchable before the political unity. The Constitution of the Nationalistic Reich is therefore not based on a system of inborn and inalienable rights of the individual. In such regimes, there is no longer any distinction between private matters and public matters. There are no private matters. The only person who is still a private individual in Germany, declared Robert Ley, a member of the Nazi hierarchy, is somebody who's asleep. To this, I add my own postscript about what this really means, and I take this from the quote-unquote infamous case of Scott v. Sanford. This is a paraphrase. And nowadays, I say in the DNSG, the de facto National Socialist Government, is that neither a lawful de jure free white state citizen, nor anyone else, for that matter, has any rights that the government is bound to respect. You figure it out. Does that sound like the government we have these days? Or are we still under the original intent of the framers? You tell me. Thank you.